Confused about U.S. immigration? Or unsure which path is right for you? At Raju Law, we guide individuals, families, and businesses through complex U.S. immigration matters with clarity and confidence. Led by attorney Raju Mahajan, our experienced immigration attorneys share practical insights, real solutions, and up-to-date guidance you can rely on. Join our free online session every Monday at 11 a.m. Eastern Standard Time, where our attorneys discuss key immigration topics and answer your questions live.
Hello everyone and warm welcome to Rajula Mondays Live. I'm Ms. Dushari Turin and I will be your host for this session. Today's topic is especially important for investors and families exploring the E-2 treaty investors visa. Capital at risk, determining the right investment amount to avoid E-2 denial. A quick heads up for all the viewers, we will be sharing our weekly immigration news update at the end of the session. So be sure to stay with us till the very end. To guide us through today's discussion, we are joined by an exceptional guest, Chelsea Smith, supervising attorney of Rajulo.
Hi, good morning. Thank you for having me today.
Good morning, Ms. Smith. How are you doing?
I'm doing well, thank you. How are you today?
I'm doing great. Thank you for asking. Our audience is very eager to understand how USCIS evaluates capital at risk and how investment amount can impact E2 approvals. Please go ahead.
Thank you. This is going to be a very interesting discussion today, and it follows nicely after our EB5 discussion last week, our investment visa that we discussed last week. We'll be discussing another version of that, which is the E2. What we want to talk about today is how to determine the right investment amount to avoid a denial. We want to talk about some of the common pitfalls and some of the things to look out for to strengthen your application. But first, let's discuss what is the E-2 Treaty Investor Visa. This is a special visa, and it allows certain citizens of countries with treaties to the United States to work in the United States, live in the United States through that investment. Well, an investor must also show that they own or control a business that's in the United States. This visa is considered a non-immigrant visa, meaning it's a temporary stay. There are some renewal avenues, which we will discuss, but it is temporary by classification, and it can support startup businesses as well as existing businesses. So this is a very useful tool for those who may be citizens of countries as part of the treaties with the United States. A treaty is an agreement at a federal level. So if your country has a treaty agreement with the United States, this could be a good option for you if you own a business or plan on starting up a business in the United States. Some things to think about if you are interested in an E-2 visa. From an investment standpoint, you must be a national of a treaty country. This is a requirement for all E-2 visa holders. We want to show also that there is an investment or that you are actively investing a substantial amount of capital. We'll discuss more what that could look like. What it means to have a substantial investment can be a bit subjective, so we'll discuss that. We will also talk more about how you could enter into the United States to develop and direct the business, but that is the purpose of the E-2 visa. We want to have that approved so that you can come into the United States to develop and direct that part of the business that is operating. So what kind of details matter about your business? We want to see that your business is real and has operating as an enterprise. We don't want to see a business that looks like a business because it has a license or some kind of incorporation, but it doesn't have actual business activity going on. So that's what it means by operating. We want to see actual business activity related to the type of business that it is. So if you have a fashion business or if you have some kind of tech business, like we want to see you doing that type of work within your business. If you're a fashion business, we want to see fashion operating activity. We don't want to see just kind of undocumented transactions. We want everything to be very clear that there is an alignment. So we also want to see the business must have like a real structure. It must have an operating agenda. It must be kind of following that trend for what you would expect for that type of business. But we also want to see profit. We want to see a business that's doing well. We want to show that they have potential beyond the minimal like living expenses. We want to show that they are in a growth, right? That they're able to sustain expansion into the U.S. or that they are able to make a diligent effort to expand into the U.S. As I mentioned, it can be a startup, right? But what we want to see is that there's this natural extension that has a more likely success rate, right? That's what they're looking for. This brings out the question of what counts as a substantial investment, which is very interesting. And last week we discussed that there's a specific dollar amount, that there is a threshold that they're looking for capital investments for E-5 visa. The E-2 is different. They want to see substantial visa or substantial investment. But that is good for maybe smaller organizations or medium-sized organizations that may have a more difficult time coming up with that capital for the E-5 investment. But maybe they're able to make an investment that makes substantial investment, that satisfies the substantial investment threshold. So let's talk about that. As I mentioned, there's no fixed amount required by law. And so things to think about is we want it to be proportionate to the total business cost. So what would that look like if you're a small, medium-sized business? We want to see an investment that is sufficient to ensure success in the business. We want to see that there's some kind of risk or irrevocably committed to the enterprise. We don't want it to feel passive or like a second priority. We want the business to have intention behind every decision that's made. And a lot of times the way that funding is allocated, you can really clearly see the underlying intention. And that's what the USCIS will be looking for. Common practice, typically we see capital investments above $100,000. They tend to kind of start heading in the right direction. But again, this will depend on your business type, the industry that you're a part of, and whether that $100,000 makes for a substantial investment will really be a personal balancing factor based on your specific information with your business and typical transactions within that company. But just to give you a ballpark, $100,000 tends to be kind of a good starting point to consider. So I've alluded to this proportionality test, but what does that mean? And so I've mentioned, unlike the EB-5, there's no fixed amount. I'm going to keep repeating that just because it's a pretty good contrast to show how different types of visas, one may be more difficult for you to meet the threshold, but maybe this speaks to you a little bit more. So with that, there's going to be factors within this proportionality test. Let's think about the location of the business. Where the business will operate will have a significant influence on investment amount. For instance, if you try to invest in a startup business in New York City, it's one of our most expensive cities. The startup cost for that would look significantly different than like the Midwest potentially, right? Because your rental rates could be different. Access to the industry could be different. All of those fees would come into play with what proportionality could look like. Cost of living, right? Also the size of your business. So if you are a large scale business, then maybe $100,000 wouldn't work for you in terms of operating costs. Again, thinking to your lease agreements, thinking to your kind of your bottom line. The thing that we want to avoid showing is that you're meeting a bottom line. We want to show that that your business is actually actively growing, that it's increasing, that there's a revenue for replenishment and plan in place. So think about your type of business. Are you a business that's mostly digitalized, well, then your infrastructure costs could be much different. So, but if you're a business who needs a manufacturing space, then you're going to need a bigger building, right? And so I'm just throwing some examples out there for you to start thinking about. But the key takeaway here is that there is a proportionality, but we want to take into consideration the location of your business, the size of your business, and the type of business. What infrastructure would you need? Where would you put it? And how many people are you planning to employ? Or how big per capita is your business currently? So thinking about that will help you determine the appropriate market research and consideration for a capital investment for an E-2 visa. Now, it's one thing to have a substantial investment, right, for the capital investment, but the other part of the complexity is proving that there's a lawful source of this investment. That's extremely important for the USCIS, and they want to clearly see the path for this funds. They want to show a successful E-2 application would show that there is lawfully obtained funding. Acceptable sources could look like the sale of property, savings, inheritance, lawful gifts, etc. We must provide evidence to support this. So evidence could look like bank records, transfer into the United States business account. It just must be very clean, very clear for the USCIS to trace it and to understand the source of the funding at hand. Now, you have real and operating enterprise. This is something that's interesting to note in this discussion because, again, going back to showing that the business must be active and producing services or goods, that's a key aspect of the E-2 visa itself. It's something that the USCIS, we mentioned, they'll be looking for this. So what does that mean? We want to show that they have a business registration. That could be an LLC, that could be a corporation. It could look like a lease agreement or a commercial location even. We want to see any required license and permits that are necessary for the operation of your business. We also want to see any kind of operating agreements, invoices, payroll, anything that may be applicable to your business. We want to see that to demonstrate that you're a real, that you have an operating business and that it's not just a passive investment by means of obtaining a visa. Now, previously we mentioned startup businesses are acceptable if the operations are ready to commence. So we don't want to show that starting the business is too far into the future or that you don't have the funding in place to start the business. What we want to show the USCIS is that, hey, I have a successful, business already, or I'm expanding my business. I've got the funding, I've got the resources. All I really need is this visa in order to make the business expansion happen. We want to show that that's really the last piece to fall into place. So we don't want it to be too far into the future. One thing to think about here is that we want to show that the enterprise or the business is going to have more than just a marginal impact. We really want to show that it has this special capacity to have an economic impact. So good for the United States, good for you. We want that mutual benefit. That also improves the likelihood of approval. So you have your sufficiency of funds. We show that it's a real enterprise with actual operation. But we also want to show that it's going to benefit the United States. And so think about being able to generate income above the investor's living expenses. Think about creating jobs. That's huge. And especially if you can show that it will happen in a short-term period of time over 5 years. We want to also show a 5-year business plan. So that is a bit of future planning. But the USCIS tends to think that a well thought out endeavor should be able to forecast what the next 5 years will look like. So we want to show projected growth, employment strategy. We want to be able to discuss that in a meaningful way that lets the USCIS know that you do have plans in place and a strategy to have a successful business. A question that often comes up is beneficiaries of a visa holder. So you have your primary beneficiary, who is the applicant, but there are other potential beneficiaries from a successful E-2 visa, which could be your employees. However, I will note that the nationality as the investor and the employee must be the same. Remember, this is a treaty agreement, right? So you have to go back to the original authority of the statute. We want to see the employees are also of that same that same treaty agreement. We want to see that that applies to them as well. And that applies to the employees who serve as an executive or supervisory, what we call essential skills role for that enterprise. So if you want to be the visa holder, but you also want to bring over your CFO or something like that, this could apply for them as well. They could also benefit from your E-2 visa. Now, in terms of family, we do have spouse and children who are under 21 who could be eligible for derivative E-2 visa status. This will allow your spouse to come over, or the spouse of the principal applicant, I must clarify. There are some opportunities for the spouse to work. There are some opportunities for your student or the children to attend U.S. schools. And that is often seen as a benefit for E-2 visa holders because then the family gets to stay together. And that's another pathway to keep your family together. As for extension, typically the initial stay is for a 2-year period, and there is some variability with this depending on consulate reciprocity. So the consular's office will play a role in some of the duration of the E-2 visa. So this will be something that could vary a bit case by case, just depending on what country you are a citizen of. The other thing is that extensions are generally granted, but they're in 2-year increments. And currently there's no maximum limit, but the investor must be able to maintain the business and the intention to depart after the status ends. So that could be something that, over time you have to continue to be able to demonstrate. Currently you can renew indefinitely, so long as the qualifying investment continues. This leads us to discussing some common mistakes and pitfalls for E-2 visa holders. First, I want to go back to the discussion of marginality. I think that that's something that, people understand the sufficiency of funds. Getting there could be, that could be some homework to figure out how to map that out, but they tend to remember that. But the one thing that tends to be forgotten is marginality. And I just want to stress again, it's important to demonstrate that the business has the present or future capacity to be able to generate significant income beyond the investor's salary. So we want to show that they're doing more than supporting themselves while they're here. We want to show that there is that economic growth, right? That's going back to that. How does this benefit the United States? You may be able to show that you have substantial funding. You may be able to show it's lawful. You may be able to show that you have a nationality with the treaty agreement, but we want to remember to show how this benefits the United States, and that's what it means by marginality. We want to go back and show that there's going to be benefit, there's going to be job creation, there's going to be economic stimulus. We want to show that there's going to be contribution to the place that you plant roots and grow your business in. We also want to point out that the idea of borrowed funds can be problematic. This includes using undocumented loans or money secured by the assets of the business itself. This can be problematic. It goes back to legitimate funding. We want to be able to show that it's very clearly obtained lawfully and well documented. We don't want to have anything that just comes in and we can't account for it. And the third thing that is a common mistake for E-2 visa applications is this concept of incomplete investment. A failure to show that the funds are actually committed and actively deployed into the business. So it's not just that the funding's there, it's that the business actually has access to that funding and is actively using it to grow and enhance their business. This goes back to having an active corporation. This kind of ties back into that discussion of showing that it's an active business and not just a shell business. We want to show that there's regular activity that's related to the type of business that it is. And this is where that comes into play. We want to show that the dollars are being invested in a way or managed in a way so that it supports the day-to-day business ventures and the continued growth of that company. Now, in terms of financial reasons for denial, let's talk about that a little bit. This concept of funding is going to be a major source of evidence for this type of visa. Think about it this way: it's an investor visa based on a treaty agreement with various countries. And so at the core of that visa classification, we have to think that there's going to be a higher evidence for showing how the funding came to be, where it came, how it got there, that those things will be at the center of a E-2 visa application. So we want to avoid this concept of idle cash. We don't want to just simply transfer $150,000 into a U.S. bank account. That's not an investment. That's a transfer, right? We want to show more than just a transfer. We want to show how you spend it. This could look like inventory, lease, equipment. This is going back to being an active business all over again. And that's what it means to put your financial money at risk. It is risk of loss if your business is not successful. So we want to show that there is a lease, that there is inventory, that there is business expenses within alignment of the type of business you have. And I'll say that again. It could be you could be in a tech industry, you could be in a fashion retail industry, you could be in a real estate industry, you could be in so many different types of business, but we want to show that that fund was not just transferred, but utilized in a way that matches to your business. And this leads us to the concept of improper loans. We've discussed this before. In the US, there are secured transactions, and this falls into the realm of securities. So it's important that your loan is part of these secured transaction channels. We want them to be documented. We want them to be secured by the business's own assets. That means that if you have a loan and you can take out a loan against your inventory, against your building, against your type of different assets that you may have available to the business. And so we want to see that. That's what an LLC does. That's what a C Corp does. We want to see the assets at risk in that way. And so personal loans, such as those secured by your house or your personal assets, or an unsecured personal loan. I think I got this backward. I think I said this backward. I'm so sorry.
That's right. All good.
Yeah, I said this backwards. I'm so sorry. Let's go back up here. For improper loans, it doesn't, it wants you to use personal loans that are secured by your house, personal assets, or unsecured. That doesn't make sense. I'm sorry. I think this slide is confusing me. Anyway, backing up, we don't want to see improper loans. Let's just leave it at that. We don't want to see loans that aren't traceable, that don't connect to the business. We don't want to see investments that we can't trace back to a secured asset that relates to the business. That's the key takeaway here. So let's leave it at that. And then we want to also avoid this concept of marginal errors. We don't want to see a business that is just paying like day-to-day existence rates and salaries. We want to show that there is a potential for expanded capacity, that there is going to be an economic benefit. We've gone over that in much more detail on prior slides. So that will be one of the financial reasons for denial, is failing to show that U.S. benefit for the area for the broader U.S. as a whole. If this resonates with you, we would love to discuss further. We have a lot of resources on our website. We have a lot of resources within our firm. This is something that we do quite often. So if you think this could be a great fit for you, I will leave this slide up here for a few minutes. We would love to connect. But this concludes my presentation today. Thank you, and we can take some questions.
All right, thank you, Ms. Smith, for that insightful presentation. We will now take a brief break of exactly seconds. Please stay tuned as the session will resume shortly.
Are you an extraordinary individual looking to take your talents to the land of opportunities? Welcome to Raju Law, your trusted partner in the pursuit of the American dream. The EB1 category is designed for individuals with extraordinary ability in sciences, education, arts, business, athletics, or any professions, as well as for outstanding professors, researchers, and multinational executives or managers. This includes individuals with a record of sustained national or international acclaim, and those who have achieved significant achievements in their field. At Raju Law, we specialize in guiding extraordinary individuals through the complex EB1 application process with ease and efficiency. We will evaluate your unique qualifications and determine your eligibility to secure this highly sought-after immigration preference. We'll highlight your awards, publications, media recognition, and other evidence to establish your extraordinary ability or outstanding researcher status. Contact us today to learn more about how we can assist you in securing your green card through the EB1 program.
Welcome back, everyone. That was a very informative session on what capital at risk truly means and how investing the wrong amount can lead to E-2 denial. Ms. Smith, we have compiled a list of frequently asked questions that many people have about today's topic. So I'll just go one by one, and then we're expecting a brief discussion from you. So the first section is investment and business structure. From that section, my first question is, am I eligible for the E-2 visa, and what is the first step?
Sure. Can you hear me okay?
Yeah, I can hear you now.
Perfect. Thank you. So to determine eligibility, your first step is going to be ensure that you are a national of a country with an active E-2 treaty with the United States. Once you confirm this, then we can evaluate the rest of your investment and business plan and then go from there. But the biggest thing to ensure in the beginning is this concept of having a citizenship with a country that has an E-2 treaty agreement with the United States.
Okay, thank you. My second question is, how much money do I actually need to invest? Is there a minimum dollar amount?
Yeah, this is a question that comes up even with this, even with a discussion about the E-2 visa. They want to know how much would be the substantial funding. So the law doesn't set a minimum amount, right? And so the investment threshold must be substantial to relative to the total cost of the business itself. For most ventures, generally, we can recommend an investment of at least $100,000 will help present a strong case.
All right, thank you, Ms. Chelsea. All right, I'm going to our second section is called operation and marginality.
Mm-hmm.
My question is, how do I prove the business is not marginal?
I love this question. It's very subjective, meaning that depending on your type of business and different case particular information, this could change slightly, but generally what we want to show, want to demonstrate the business's capacity to generate income that is significantly above your living expenses. And we want to show the ability to hire U.S. workers within 5 years' time. We want to also support this with a 5-year business plan that shows the growth and employment plans. So this is kind of a thing that becomes tailored to the individual client or the business at hand. So we work with it that way.
All right. Thank you very much. My second question is, does my E2 business have to hire a specific number of US workers?
So that's an interesting concept as well. There's no specific number, but what does that mean if your business isn't marginal, right? So we want to just demonstrate that the business has a capacity, either present or future, to generate significant revenue beyond that is necessary to support you and your family. We want to show that hiring staff is a way to show and prove to the USCIS that there is an economic impact. So while it's not about a number of employees that you hire, we want to show that there is an economic benefit. One of the best ways that we can do that is by hiring U.S. workers, right? Stimulating the economy in that way.
All right. Thank you so much. Okay, now I'm going to section C. It's called duration, renewal, and transition. From that section, my first question is, how long is the E2 visa valid for, and how long can I stay?
Right. So the validity of the E2 visa is going to be that there's a duration for the initial 2 years. That's the initial duration. But it can be up to 5 years. Again, this goes back to the consular agreements. So this will be another important way that initial treaty agreement can later dictate the duration of your E2 visa, right? It could vary based on that treaty agreement with your individual country. It's typically the period of stay upon entry is typically granted for 2 years at a time. The visa validity for travel depends on the treaty country, and it can be up to 5 years.
All right, thank you so much. My second question from that section is, can the E2 visa be renewed indefinitely?
The answer in short is yes. As long as your business remains fully operational and it continues to meet the E2 criteria, specifically, we want to emphasize that marginality requirement, right? The non-marginality requirement. There is no limit on the number of 2-year status extensions that you can receive.
All right, thank you so much. Now I'm going to our section D. It's called family and process logistics. From that section, my question is, can my spouse and children come with me? Can my spouse work?
This is a great question. It's one that's of common concern for visa applicants. The answer to your question is yes. Spouse of the primary beneficiary and unmarried children under the age of 21 can accompany the primary beneficiary holder of the E2 visa. The spouse is eligible to apply for the EAD upon arrival and can work for U.S. employers. That is the basic, arrangement. So that's, I think that answers your question. What is the next one?
Okay, my next question is, what happens to my children when they turn 21?
Yeah, so that's another common question we have. It's a concept of aging out of their derivative E2 status. They'll either, at that time, they'll age out and they must either leave the United States or successfully switch to their own non-immigrant status, such as F1 student visa or some other visa to remain legally within the country.
All right. Thank you, Ms. Smith, for explaining these complex issues so clearly. I'm sure our audience finds this guidance extremely helpful. Before we wrap up, do you have any final advice for investors who are considering an E2 visa and are unsure about how much they should invest or how to structure their funds properly?
Yeah, I think that connecting with an immigration attorney is going to be pretty great advice, especially for the E2 visa, because it is a subjective analysis. The other thing that I will clarify that I haven't yet is that processing times can vary by the consulate. So once all the documents are prepared, the consular will review. They'll schedule the interview if applicable, and that can take anywhere from 3 weeks to 3 months or more once it's submitted. So our priority is to submit a perfectly organized package. That in our practice, it helps minimize delays. So that would be my closing remarks, is to show great evidence, be able to account for every dollar, be able to show that you are an active organization, and the more clean that your evidence is, I think that the more easy it is for the USCIS to review it and therefore approve it, minimizing delays. Those are my final thoughts, and I really appreciate being here today. I'm very, very happy to have another chance to do a Monday Live. It's a fun opportunity and a great way to discuss immigration topics. So thank you for having me, and thank you for being a great audience.
Thank you so much, Ms. Smith, for joining us today and sharing your valuable insights. It's always a pleasure having you with us.
Thank you. Thank you.
All right, that brings us to the final segment of today's session, our weekly immigration news updates. Thank you to everyone who stayed with us till the end. Before we close, let's take a quick look at the most important immigration updates from this week that you should be aware of. Until next time, this is Ms. Dushari Turin signing off. Stay informed, stay ahead, have a great day.
Hi everyone, welcome to this week's immigration update from Raju Law. We bring you the latest news, USCIS updates, and policy changes that matter. This week's top stories include: Nebraska court rejects USCIS final merits rule for EB-1A petitions. Fiscal year 2027 H-1B cap initial registration opens March 4. Trump immigration approval hits new law. Ice roll at Italy Winter Olympics draws criticism. Let's begin with a key court ruling affecting EB-1A petitions. The USCIS District Court for Nebraska ruled that USCIS's two-step adjudication process for EB-1A petitions, including the final merits determination, was not validly created and did not follow proper rulemaking procedures. The court stressed it was reviewing the legality of the framework, not the merits of the petitioner's case. Next, important news for H-1B applicants. USCIS announced that the initial registration for the fiscal year 2027 H-1B cap will run from March 4 to March 19, 2026. Employers must register electronically using a USCIS account and pay a $215 fee. This year, the selection process will prioritize higher skilled, higher paid candidates. If registrations exceed the cap, a weighted selection will be used. Selected petitioners may also need to pay an additional $100,000 fee before filing. Now, public opinion on Trump's immigration policies. A Reuters Ipsos poll shows Trump's immigration approval has dropped to a record low since his return to office. Only 39% of Americans approve of his immigration policies, while 53% disapprove. Many respondents feel enforcement tactics, including ICE actions, have gone too far. Finally, U.S. immigration agents are part of international operations. ICE agents will support U.S. security efforts during the Winter Olympics in Italy. Some Italian leaders criticized the move, emphasizing that Italy will lead and control all Olympic security. U.S. agencies will operate from a consulate-based coordination center in Milan. That wraps up this week's immigration updates. Stay connected with Raju Law for more news, insights, and guidance. See you next week with the latest developments in U.S. immigration.